civil fraud judgment. But his lawyers told the appeals court that more than 30 bonding companies rejected him. They said it was a practical impossibility to secure a bond at large. Then, just days before the deadline, when New York Attorney General Letitia James was preparing to seize Trump Tower and other properties, an appeals court panel stepped in and slashed the required bond to $175 million, giving Trump a lifeline. Even then, Trump barely made the deadline, posting the bond on the last possible day. The bond is a placeholder that guarantees payment if the judgment is upheld on appeal. If Trump loses, he'll owe the full $454 million plus interest, is accruing at more than $114,000 per day. If he wins on appeal, he gets the $175 million back. But the fact that Trump needed a high-risk lender and a last-minute court intervention to avoid asset seizure tells you everything about his actual financial condition. This is not a billionaire flush with cash. This is someone whose empire is held together with duct tape and borrowed money. Now, let's be honest for a moment. Mainstream coverage often focuses on headlines, but skips the context, incentives, and power dynamics behind the scenes. That's why this channel exists, to break down what actually matters based on public reporting, institutional rules, and how power really works. Want to stay ahead of these stories? Make sure you're subscribed. We bring context, not spin. All right, let's get back to what just happened. Here's what actually happened in the New York civil fraud case that led to this judgment. Attorney General Letitia James began investigating the Trump Organization in early 2019, focusing on whether Trump and his company fraudulently inflated the value of his properties to get better loan terms and insurance rates, while deflating those same values to pay lower taxes. The investigation led to a lawsuit in August 2020, and the trial ran from October 2023 to January 2024. Judge Arthur Engoron presided over the trial. In September 2023, even before the trial began, Engoron issued a summary judgment finding that Trump and his company had committed fraud for years. The judge ordered the termination of Trump's New York State business licenses and the dissolution of the relevant limited liability companies. Though these orders were stayed pending appeal, the trial then addressed 6 additional claims and considered further penalties. On February 16, 2024, Judge Engoron issued his final ruling. He found that Trump, his adult sons Donald Jr. and Eric, former Trump Organization CFO Alan White, and other executives had submitted blatantly false financial data to financial institutions in order to borrow more and at lower rates. The financial statements submitted to banks and insurers wildly overstated the value of Trump's properties. For example, Trump claimed his penthouse apartment in Trump Tower was nearly 30,000 square feet, when it was actually about 11,000 square feet, tripling its value. He valued Mar-a-Lago between $426 million and $612 million, based on the idea it could be developed and sold, when in reality, Mar-a-Lago is subject to a conservation easement that permanently restricts it to use as a social club, making its actual value a fraction of what Trump claimed. Judge Engoron wrote that the defendants failed to accept responsibility or to impose internal controls to prevent future recurrences of the fraud. The penalty was staggering: $364 million in disgorgement of ill-gotten gains, plus interest. With interest, the total owed was $454 million, growing by more than $114,000 per day. Judge Engoron also banned Trump and his co-defendants from serving as officers or directors of any New York corporation for 3 years for Trump, 2 years for his sons. The judgment was a total repudiation of Trump's business practices and found systematic fraud over many years. Trump immediately vowed to appeal, calling the case a witch hunt and claiming Judge Engoron was biased. But under New York law, to appeal a civil judgment, you have to post a bond for the full amount, or the state can start seizing assets to collect. That's when Trump's financial problems became acute. Now here's where this gets bigger than it looks. Trump's lawyers went to 30 different bonding companies trying to get someone to underwrite a $454 million bond. All of them said no. The reasons reveal why Trump is in such a precarious financial position. First, bonding companies require collateral that covers 120% of the bond amount. for a $454 million bond. That means Trump would have needed to put up more than $545 million in collateral. Second, underwriters insisted on liquid collateral, meaning cash, stocks, or other easily sellable assets. They would not accept real estate as collateral, because real estate takes time to sell and its value can be disputed. Third, bonding companies were spooked by the fraud judgment itself. If a judge has already found that Trump systematically lied about the value of his assets, why would a bonding company trust Trump's claims about what his collateral is worth? Trump's lawyers filed a motion with the appeals court saying it was a practical impossibility to get a bond for the full amount. They claimed Trump had cash but wanted to keep some available for his presidential campaign. But the reality that Trump couldn't get any mainstream bonding company to take his business suggests he doesn't have nearly as much liquid wealth as he claims. Trump has repeatedly boasted about being a billionaire with massive cash reserves. In March 2024, he claimed to have almost $500 million in cash. But if that were true, he could have posted the bond himself, or easily gotten a bonding company to underwrite it with that cash as collateral. The fact that he couldn't do either suggests that cash doesn't exist in the amounts he claims, or it's tied up in ways that make it unavailable. On March 25, 2024, just days before the March 25th deadline, when Attorney General Letitia James could start seizing Trump's assets, a New York appeals court panel did something extraordinary. They slashed the required bond from $454 million to $175 million and gave Trump 10 more days to post it. This was a huge gift to Trump. The appeals court didn't explain their reasoning in detail, but they essentially decided that requiring the full bond amount was too onerous and that $175 million was sufficient to protect the state's interest. Legal experts were stunned because it's extremely rare for an appeals court to reduce a bond requirement so dramatically without a full hearing on the merits. Some speculated that the appeals court judges, some of whom are Republican appointees, were sympathetic to Trump's arguments that the fraud case was politically motivated. Others thought the court was simply trying to avoid the spectacle of the state seizing Trump, Tower, and other iconic properties which would have dominated the news for weeks during a presidential campaign. Whatever the reason, the reduction saved Trump. But even with the bond slashed to $175 million, Trump struggled to come up with the money. He didn't post the bond until April 1, 2024, the last day of the 10-day extension, and the bond came from Knight Specialty Insurance, part of the Knight Insurance Group, a company run by billionaire Don Henke. Henke is known in the business world for making high-risk, high-interest loans to car buyers with flawed credit histories. It's subprime lending for people who can't get traditional financing. That's who Trump had to turn to. Henke told the Associated Press that both cash and bonds were used as collateral for Trump's bond, and that he's never met or spoken with Trump. Henke said, "This is what we do at Knight Insurance, and we're happy to do this for anyone who needs a bond." But the subtext is clear. Trump couldn't get a bond from any reputable company, so he had to go to a specialist in high-risk deals. That's humiliating for someone who claims to be one of the wealthiest people in America. Attorney General